Haji is this morning addressing all DPP heads of county attending a plea bargaining workshop in Naivasha. Let's cross over and listening to what is going on. All right. Now, that workshop is currently happening in Naivasha, but before we give you that live picture of what is happening there, let's talk to our reporter, Brian Obuya, who's keeping tabs at that workshop. Obuya, good morning. And this workshop comes at a time when the DPP is handling a lot of high-profile cases and also introducing new investigative officers into his team. Brian Obuya, if you can hear me.
Good morning, Brenda. Good morning, Brenda. And so the DPP is not here yet, but as you clearly put it, is that he's set to address heads of counties in matters prosecution on plea bargaining. So what is set to be discussed today is the circumstances under which the Office of the Director of Public Prosecutions can enter into a plea bargain with the accused person. Just maybe to paint for you a picture of what we are talking about here is that Nurdin Haji's office may choose to decide or rather agree with an accused person that they are going to plead guilty to an offense they are accused of, and in turn the office is going to negotiate with them the circumstances and the outcomes of the case that are favorable both to the prosecution and to the accused person. This type of method of litigation has been happening in other countries, even here in Kenya. It has been on test for a number of times in different courts, like the children's court, murder cases. We've had it in children's courts, murder cases, and also corruption cases where people choose to plead guilty to certain offenses which they basically understand clearly that the prosecution has overwhelming evidence or to charge them on some counts. But if these counts are, let's say, they're being charged with 15 counts of corruption or rather 3 counts of murder, and the DPP believes that he can only prove 2 of those, they may choose that he pleads guilty to only 1 of them, and the DPP believes that, or the Office of the Director of Public Prosecutions believes that this is a way that is going to help them take the shortest period of time to reach a just conclusion. You want to remember that we are talking about a country 55 years after independence where we are having trials lasting for as long as 30 years. You saw the other time when we are talking about the Changuli fire tragedy, whose trial lasted 14 years and a compensation row is going into its 3rd year. We've seen murder cases in which people were charged in the 1990s, and those people to date, the trials are okay. They appeared before court. The trials have not taken place yet. So this is a type of litigation that the Office of the Director of Public Prosecutions, of course, pursuant to Section 137, they are entering into agreements with accused persons that they are going to plead guilty. But of course, they are today going to discuss the circumstances under which they are going to enter into agreements with these accused persons. They are going to discuss under what circumstances can they terminate a plea bargain agreement, and what circumstances are they going to terminate the same, including in cases of misrepresentation, or whereby, or rather in cases of fraud, in cases where there is coercion, whereby an accused person, it is found out, was coerced to plead guilty to certain offenses, or in circumstances again, Brenda, where an accused person, rather a plea bargain agreement, has been rejected by the court. And this has been a 4-day conference that ends tomorrow, and we expect to see the DPP address the conference and again introduce the Queen's Counsel, Kawar Qureshi, whom yesterday we saw in court with some fireworks during that Justice Mwilu's trial. So it's something we continue to wait and see what the DPP has to say about it. But right now, what's happening is there's a private session going on between among those county heads of prosecution. And once the DPP comes to address, then we probably get back to you. But they believe that this is going to be one of the best ways of achieving justice in the easiest and the fastest way possible, especially when they are able to reduce charges, or rather someone is charged with 15 counts of corruption, they're able to plead to just 4, and the rest are reduced, and a sentence is maybe proposed by the prosecution. A murder case is someone pleads guilty to a murder case, and maybe the charges are reduced to manslaughter. We've seen it happen before. And one of the highly suspected cases where plea bargaining has also worked, which those in the circles of litigation believe has worked, is the Akasha case that has that now affidavits are mentioning senior government officials and judges and former ministers in the country, whereby these people pleaded guilty to those particular offenses. So it's a conference. We wait to see how it ends and how in future the plea bargain agreement is going to work for the judicial service in this country, and whether or not it's going to reduce the time used for these trials to take place as opposed to what we've been seeing in the past. Brenda.
All right, and before I let you go, you've actually mentioned some of the cases that the DPP will use when it comes to this plea bargain. But then the question is, there is a concern that some people, some accused, may use this as a way of a scapegoat in terms of, avoiding being charged in court.
Well, Brenda, what you have to understand and what our viewers need to understand from the onset is that a plea bargain agreement only applies when actually people plead guilty. So from the onset, these people are going to be charged in court, and they are possibly going to be convicted. It's only going to work in cases whereby it's going to reduce the time used for trial, and that these people are now going to be charged with a lesser charge than what they are capable of being charged with. If someone has to plead guilty to a murder, and those are very delicate cases, by the way. Nowadays, you don't just plead guilty to a murder case. You have to undergo a mental check, and also the prosecution is making it clear to those who are entering into this particular type of agreement with the Office of the Director of Public Prosecution that by entering into this type of agreements, it does not bar other agencies from who are interested and are not part, who are interested in them in the cases, but are not part of the plea bargain agreement, from further investigating and charging them afresh, unless these agencies are later on brought on board and made to be part of the plea agreement. What we basically are saying, Brenda, is that if the EACC charged someone with fraud and they pleaded guilty to it, and they entered into a plea bargain agreement, if the DCI or rather any other body is not informed and made part of that agreement, it will not stop them henceforth from charging these people with all these other offenses that they had earlier on agreed with the prosecution to overlook, or that type of thing. But again, there are also ways in which this type of plea bargain agreement can also be terminated in cases, like I've told you, of fraud, in cases of misrepresentation, like you've said. If people are using it as a way of trying to have themselves not charged, then the prosecution could later on find that there was some sort of misrepresentation or non-factual information that was given to them, and that one then makes sure that they are actually the plea bargain agreement is cancelled by the court, or just either of the parties involved, including the accused persons.
All right, thank you so
Brenda.
much. Thank you so much, Brian Obuya, for that intense explanation. Our investigative reporter, Brian Obuya, right there, bringing us up to date with what is happening in Naivasha. Now, it is